Huh? Okay, so last week we covered requisitions in the agreement of purchase and sale. Okay, I want you guys to answer the following question. You should be able to answer this now. So, as a seller's lawyer, I get requisitioned. Buyer's lawyer finds a lien registered in favor of CRA against title. Okay, so naturally, what's the buyer's lawyer going to want? They want clean title. They want that to be removed off title, right? So in their requisition that they're going to submit to me, they're going to say, we found the following lien registered in favor of the CRA, and on or before completion of the transaction, we want it paid out and discharged. Okay, so what we discussed last week was that in order for me to do that, I need to now contact the CRA, right? I'm going to contact the CRA and I'm going to say, okay, I need a payout. There's a registered lien against my client's property. I need to know how much to pay out. Okay, it's tax season. This is actually a real scenario that happened today. That's why it's very relevant. Okay, so because of the tax season, the CRA is taking their sweet time and they're not responding to us. When a buyer's lawyer requisitions, and this is the real question here, when a buyer's lawyer requisitions pursuant to the agreement of purchase and sale, you guys should know now that either the buyer may be able and willing to remedy. Is the buyer going to take title subject to a lien? No. Secondly, the seller may be able and willing to remedy. If the seller doesn't know the full payout amount, can they remedy it? No. So in this situation, on behalf of the seller, we said, look, the lien is $14,000. We'll hold $25,000 back. Seller's lawyer said that's not acceptable. We're not closing. Is that a reasonable response? That's the question. Can the seller's lawyer refuse to close as a result of that? What's the third option they should have in this situation? Very good. Okay, so if neither the buyer nor the seller are able and willing to remedy the situation, if title insurance can step in and paper over the policy, that's it, the deal closes. The lawyer sends a nice love letter saying, we're not closing, you're in breach of contract, this bullshit, that bullshit. My simple response was in accordance to clause 10 of the agreement of purchase and sale. It very clearly says if there's a title insurance policy that can paper over the issue, you're going to close.
Did they have that?
They did.
Okay.
And even if they didn't, I could have purchased a policy on their behalf to support that cause.
Even after the fact of all this happening?
Well, this is literally minutes to 5 before registration.
Okay.
And they're like, we're not closing. And so I'm like, if you don't close, you're in breach of contract.
Sorry, let me get this straight.
Yeah.
So there was a lien on the property as per the sellers.
Well, when they checked the title of the property,
$14,000.
that's right. Yeah.
Okay. And the buyer said they're not closing?
Buyer said that because you don't have a payout, we're not closing. We refuse to close.
Okay. So that would put the buyer in breach of contract?
Well, if they failed to close, so unless we exhaust all three options, buyer said we're not dealing with it. Seller says I can't deal with it. I'm prepared to give a holdback and double the amount, but that's all I can do. I need the money to close my other property.
So they offered a remedy.
Yeah, so the seller did remedy. He offered to remedy, but they said that's not acceptable because we don't know if there's interest in other things that are accruing. Fair enough. So in this situation, when they tried to walk away, and I suspected that they just wanted to walk away from the contract, we came back and said, well, if you look at the agreement of purchase and sale, if we can get title insurance to cover this, you're going to close. And that was the end of it.
So you were on the buyer's side?
I was on the seller's side.
Oh, you weren't?
Yeah.
I thought the sellers couldn't get the title insurance.
No. Seller, no. So the agreement says that if the buyer's lawyer can't get a title insurance to paper over the issue, then the deal would fall apart. That's when the sunset clause kicks in. My point in this example, there's 2 points to make. One, if you don't know what you're signing, the realtor was totally lost in the situation, had no idea what to do in this given situation. Frankly, it wasn't their job at this point because it was with the lawyers. But the point is that when the client's panicking and things are going wrong, the last thing you need is a crazy realtor who doesn't understand the bloody contract that they had executed and then adding fuel to that fire. So it was all resolved, but I want you to understand that in a situation like this, if neither the buyer nor the seller are able and willing in accordance with clause 10 for title, which clearly says, unless there's a mortgage being assumed that's agreed to, we need a discharge. Any liens and encumbrance that are not being, that are on title have to be discharged, which is fair. That's what the contract says. To reiterate, you guys need to know what's in the contract because you have to explain that to your client, right? We got this file last week. And so for us to go to the CRA in tax season to get a payout is impossible. They're going to take 6 months to deal with this. So the answer in this situation is that you acquire title insurance, they policy over it. So title insurance contacted us and said, okay, the $14,000, we want you to hold back $25,000 and give an undertaking. That was the end of it.
So basically, if there's a lien on a property and I buy a property, let's just say, how quick can I find out if there's a lien on it?
And this is where Clause 8 title search comes in. You guys set the requisition date, right? Remember, we talked last class that there's a title search date which you put in, which should typically be 2 weeks before closing, right?
But why so late?
What's that?
Like, let's say I purchase property now, right? I'm closing it all the way in November
Yeah.
or July.
Yeah.
Why requisition it so late?
Because you don't want to requisition it so early on either, right? There's conditions, there's other things happening. And so with residential transactions, for the most part, 99% of things are resolved. The agreement of purchase and sale created by OREA and drafted by OREA is very good as a contract. If it's a commercial policy, that's a very different story.
But then
Because
all the way in November, I can find out there's a lien.
But that's
on the
okay, because in this situation, title insurance covers it anyway, so we don't care. You get what I'm saying? So what I want to get across here is that in the agreement of purchase and sale, the buyer may be able and willing to remedy. If they can't, then the seller may be able and willing. We were. They didn't accept it. That's the only thing. And if not, then title insurance covers it. If neither one of these three parties deals with the issue at hand, the deal will fall apart. Okay? That's really, really, really key that you understand that.